Varieties of contracts. There are many different terms that are applied to describe contracts. An executed contract is completed and has been fully performed on both sides. An executory contract is one that has not been fully performed on both sides. Some duties remain to be completed. The contract for the painting of a house would be executory if the painting had not yet been fully completed and the payment for the work had not been made. A bilateral promise is an exchange of one promise for another promise. A unilateral promise is an exchange of one promise for an act. So if the homeowner offers to pay the gardener $10 for mowing the lawn, the gardener need only mow the lawn to accept the offer and perform the contract. Certain types of contracts are required to be in writing and signed by the parties. But many contracts can be formed without any writing at all, and some can be formed without even a verbal exchange of words. An express contract is communicated between the parties in oral or written words. An implied-in-fact contract is a contract agreed by non-verbal conduct, rather than by explicit words. An agreement implied in fact is founded upon a meeting of the minds, which, although not embodied in an express contract, is inferred as a fact from conduct of the parties, showing in the light of the surrounding circumstances their tacit understanding. Such contracts are formed when one party accepts something of value, knowing that the other party expects compensation. For example, by visiting a doctor, a patient agrees to pay a fair price for the services. If the patient refuses to pay after being examined, she's breached a contract implied in fact. Generally, an implied contract has the same legal force as an express contract. Typically, unilateral contracts are the subject matter of these types of implied-in-fact contracts, where acceptance is being made by beginning a specified task. A quasi-contract, also known as an implied-in-law contract, is a legal substitute for a contract. A quasi-contract is a contract that should have been formed, even though in actuality it was not. It's used when a court wishes to create an obligation upon a non-contracting party to avoid injustice and ensure fairness. It's invoked in circumstances of unjust enrichment. An example of a quasi-contract is the case of a plumber who accidentally installs a sprinkler system in the lawn of the wrong house. The owner of the house had learned the previous day that his neighbor was getting new sprinklers. That morning he sees the plumber installing them in his own lawn. Pleased at the mistake, he says nothing and then refuses to pay when the plumber hands him the bill. Will the homeowner be held liable for payment? The answer is yes, if it can be proven that the man knew the sprinklers were being installed mistakenly. The court would make him pay because of a quasi-contract. If that knowledge could not be proven, he would not be liable. A modification is a contract to amend another contract. The regular rules of formation apply to a modification as apply to the original contract. Modification of an agreement must be in writing if the agreement as modified falls within the Statute of Frauds. It involves consideration for marriage, cannot be performed within 1 year, a transfer of interest and land, and so on. So, if a 12-month verbal contract is modified by extending it to 13 months, the verbal agreement for the extension is not binding, as it means the contract as modified extends beyond the 12-month cutoff, and a writing is then required under the Statute of Frauds. If the original agreement specifies that modifications will be valid only when written, this provision is effectively ignored under the common law. The Statute of Frauds trumps the contractual agreements between the parties, and this is one of the rare situations where the law restricts the abilities of contracting parties to set the terms of agreement. So if no writing is necessary under the Statute of Frauds, then an oral modification, absent a writing, is binding on the parties. The UCC is again more liberal, and provisions requiring modification in writing are respected for the sale of goods. A verbal modification would be invalid for a contract involving goods, but would be valid for a contract involving services. A modification is really a new contract, so it requires consideration. That's true under the common law for services and other contracts, but when we're dealing with the sale of goods and the UCC, no consideration is required for a modification to be effective. A requirements contract is a contract in which a supplier agrees to supply as much of a good or service as is required by the customer, and in exchange the customer expressly or implicitly promises that it will obtain its goods or services exclusively from this supplier. For example, a grocery store might enter into a contract with the farmer who grows oranges, under which the farmer would supply the grocery store with as many oranges as the store could sell. The farmer could sue for breach of contract if the store were thereafter to purchase oranges for this purpose from any other party. The converse of this situation is an output contract, in which one buyer agrees to purchase all the goods or services the seller is able to produce. Illusory promises are so named because they merely hold the illusion of contract. For example, a promise of the form, "I will give you $10 if I feel like it," is purely illusory and will not be enforced as a contract. It's a general principle of contract law that courts should err on the side of enforcing contracts. Parties entering into the arrangement presumably had the intention of forming an enforceable contract, and so courts generally attempt to follow this intention. An illusory promise is one that courts will not enforce. However, courts will often interpret the agreement as an implied-in-law contract and find a way to enforce a promise in order to avoid injustice. An option contract is an agreement providing one party with a right, but not an obligation, to close a transaction with the other party at a future point in time. An option contract is a type of contract that protects an offeree from an offeror's ability to revoke the contract. Consideration for the option contract is still required, as it's still a form of contract. Typically, an offeree can provide consideration for the option contract by paying money. An illegal contract is an agreement whose formation, object, or performance is so iniquitous against the law of the land or contrary to public policy that no court will entertain or enforce it. Technically, it's a no contract. In situations where two wrongdoers enter into an illegal contract and one of them takes advantage of the other, law normally will not intercede to remedy the situation. A valid contract is a regular, enforceable contract. A void contract has no legal effect. It's as if the contract had never been formed. In a voidable contract, at least one party has the option to avoid their obligations. An unenforceable contract is an agreement that cannot be enforced by the courts due to a defense of the breaching party.